So in any event, if I can proceed. So, again, I'm not trying to quarrel with you that from your perspective, I understand why you believe you're entitled. I'm just trying to say, I think from where I sit, it's not clear cut that you're entitled. But regardless, I think from Tom's perspective, with regard to the sacrifice that you made and clearly the injury that you sustained, he engaged and he had the office engage. And so as a result, I had negotiations to see if we couldn't come to some resolution for you. And again, that resolution was on the table at some point, at least kind of some general framework. Subsequent email was received, and they then retreated a bit. At that point in time, I asked them to give us an opportunity to sit down with you, to have a conversation to see if it was of interest. They've allowed me that opportunity to say, we'll remain open. We won't process the appeal at this point to see where things stand, but they were pretty candid to say they don't know if they're willing to look at what was kind of the scope of the original agreement. Because I think their concern is that from their perspective, and that's why I think it's important in terms of the fundamental disagreement that I think exists between your believing this is very clear cut and they're believing you're not entitled because you're eligible for other reasonable employment, and that's where the real disconnect is. That
then why don't they make that determination so we can take this to court?
So, and they're prepared to do that.
That's my question. Why if that was if this has been their position, and obviously it has been because they've been dragging their feet. And level 1 appeal should have taken 90 days. The level 2 appeal should have taken 90 days. The level 3 appeal should have taken no more than 90 days. This should have all been settled.
Absolutely.
Over a year ago.
Yeah.
15 months ago. We should have been. Then we could take it to circuit court and make that decision.
Don't disagree with any of that. It wasn't. It hasn't. But I'm telling you, that's the fundamental disagreement, and that's important for this reason. And the reason is because the offer that they put on the table would require you to sign a confidentiality agreement, which is very typical in any settlement case. And from their perspective, the reason that that's important is because they have to be concerned about all the other claimants that are behind you. And so their position is, if we've settled a case that, from our perspective, isn't the strongest case in the world against us, we now have to worry about every case coming behind it to point to Wade Roberts' case and say, here's his circumstances. From our perspective, the department, he was able to hold other employment. You disagree, I get that. But again, from their perspective, he's able to hold other employment. Every other case that comes behind you without a confidentiality agreement, non-disclosure agreement, is going to then cite your case as precedent. So from their perspective, that's a very important piece to this. So when you wrote that email, followed when we attempted to communicate this to you originally, from their perspective, the signal was he's never going to abide by NDA, non-disclosure agreement. So why would we even try this? So when
I see, I now I know what email you're referring to when I was discussing the fact that I wasn't going to sell my First Amendment rights.
Yeah, you analogize that to Tom's second.
That more clearly explains it. That I wasn't willing to give up my First Amendment rights to speak about this.
That's right. That's exactly right. And you don't have to. And
again, I understand that.
All this is your decision in the end. So in any event, I then asked them to at least give us an opportunity to talk. Through that, they essentially said, well, we'll give you that, but we don't know if we'd ever, at this point, agree to a settlement with the belief we now hold. But maybe we'd look to get some resolution some other way. So let me kind of put on the table.
Okay, yeah, let's hear what it, let's hear
what I think 2 potential avenues for resolution are. Okay? So the first avenue, which I would like to think they would still consider if it's of interest, would essentially say, there'll be a settlement of your case, that you'll receive those benefits. They use some specific language and it would be in an agreement, but essentially until you're able to collect, I assume, Social Security. So it's for your working lifetime, I guess, as it was explained to me. And additionally, then there would be a lump sum settlement. We'd have to settle on what that number is for past benefits due to you. The question I had, which I think would be the obvious question you would ask, is, and let me just add, and to get those terms, there'd be required a non-disclosure agreement. The question I had when that was explained to me was, if I'm you, I want to know, why am I not going to be back in this circumstance when Tom's out of office or some other administrators in the department, and they're just going to then say, you don't have any updated medical, therefore we're going to, because part of this would be that ongoing weekly or biweekly or monthly payment, whatever your payment looks like under the long-term disability.
It's been a monthly payment,
So-
the 1973, but.
So whatever that is, my question then was, once he's gone and nobody's holding their feet to the fire, or once there's new bureaucrats in.
Well, Tom's not responsible for the situation that I'm in.
No, but I think he's got the retention, okay?
In any way, shape, or form, is Tom responsible?
Yeah, well, but I think he's got their attention. So I'm
I
thinking,
appreciate
yeah,
that.
I think I'm trying to think through the mind of. I'm trying to anticipate concerns that you would have in, if you were to agree to this, what blows it up in the end. And the concern I would have if I were you is, once he's gone, if indeed that's part of the reason they've come to the table, or once the bureaucrats that are agreeing to this are gone, how do you know you're still going to get that monthly payment and they're just not going to go require you to take another IME? So that's essentially what I was trying to get at with my question to them. How do we know you, the department, are not going to subsequently require him to go get an IME and then determine once again that he's not eligible, those monthly payments stop, and we're
Break
back
the
in the
deal.
same situation. So what I was told at that point was there would be no requirement for a subsequent IME. That is done as part of this agreement. That's over, done. But what would be required is, apparently you need to, is it annually, submit a statement with a signature that essentially says there's been no change in your medical condition. So long as that statement is submitted annually, their file's papered to say that that's what's required in this circumstance, and your benefits then continue. So that's kind of the general framework of the first agreement that was conceptually on the table. So again, I would like to think that if that's of interest and we go back, that'll be there. But what they've talked about more recently is just granting your appeal, and there won't be any back settlement, and moving forward at that point. I think from their perspective, there's a practical side to all this, and that is, how much do we continue to invest in this? How much do we continue to be concerned that you have a legislator, a senator, engaging our director, and you have an office engaging us regularly? And so that was our second conversation, what they started to talk about. And I think, again, from their perspective, the reason that they then started to think in those terms is because if they just grant your appeal, there's no record of it. There's no settlement that another attorney with another claimant can then point to if there's no non-disclosure agreement. So the appeal is just kind of on its face. Granted, attorneys can look at that all day long who have other claimants, and they can't understand, because there's no record of it, why it's being granted. Unlike a settlement, that if it is not protected, attorneys with other claimants coming behind you can look to and say, my guy's worse than Mr. Roberts. Why did you settle his case and not mine? So I tend to think, if either or both of those are of interest, that with some additional conversation, your preference would be on the table. But, and I certainly don't expect, unless they're just, you want to summarily dismiss them, but I certainly don't expect you to walk away at this point and give us an answer. Certainly,
Well, I
take
appreciate
some,
that. Yeah.
some study on your part, but I think with added conversation, that's a direction that's available for you. So that's what I know.
We talked at one time about making me whole.
Yeah. Yeah, so I don't know what your perspective of whole is. I think that's more along the lines of so again, I don't know if you consider that to be your time, your expenses. I can tell you those are off the table. But I think making you whole is more along the lines of that first offer that was on the table, and that is granting your, well, excuse me, long-term disability going forward, and then lump sum payment in regard to all that you've been off. Oh, hi there. Well, like the coat. Although they haven't, sorry, I'm late. No, you're fine.
again.
Is this your dad?
Yes, it
Yeah,
is.
Marty Fitanti. Yeah.
Met
I
you
work with-
once before.
Oh, okay. No, that's Tom.
I know.
Yeah, he's the better looking one, so,
Yeah.
yeah.
You're just bribing them now.
Yeah, I got to. I work for him. Well, thanks for coming. So I was just outlining to Wade some options that may be on the table for him to consider. I think that making you whole.
The question I have regarding making me whole in my mind,
Yep.
what my definition of making me whole is what I would have had I been treated properly from the day of injury and gotten my administrative leave, which was per policy what should have happened at the time, which would mean I would not need LTD. I would be getting my retirement.
Yeah, I can tell you that's just not on the table. So I think you've got two potential options in front of you. And one is if you want to keep your ability to talk about how bad the department is, how bad you've been treated, and how you've gotten screwed. And the other is it's going to require you to give up some of your First Amendment rights and sign a non-disclosure agreement.
Well, you're saying a lump sum amount.
Right.
What lump sum amount are we talking
I've
about?
not talked about that. I've not engaged in that negotiation because at this point, from my perspective, it's wasted conversation if you're not interested.
I would say it's gonna need some participation from you.
And we're only talking strictly about is my experience with the Michigan Department of Corrections,
I don't know if I follow you, Wade.
non-disclosure.
No, I think you can bitch all you want about the DLC. What you'd not be able to disclose are the terms of the settlement. So in other words, if there's a settlement under the first offer, right? If there's a settlement.
So you're not saying I have to squelch the story of my, let's say I publish an autobiography
Yeah,
of my
right.
experience. You're saying there's no need to squelch that.
The only thing you'd have to squelch is that there was a settlement and what the terms of that settlement were.
The amounts and
You-
what
you-
you're
You
gonna end
can't-
up with.
You can't say, if this were the path you were to follow, you cannot say that the Department of Management and Budget offered you a settlement, you took the settlement, and here's what the terms were. You can't say those three things. Beyond that, you can complain about anything you want. You can say anything you want.
That makes sense?
Again, the rationale for that is they want to protect the integrity of the plan. That's what all this is about from their perspective. I know you disagree with that, but I'm telling you what they are concerned about is the precedent. And the
The
precedent,
plan has lacked integrity.
again, I'm not arguing with that. I'm just telling you the perspective of the bureaucrats.
I mean, you are aware that they tried with the Gaylord appointment.
Very aware of it, yeah,
They sent me to another
yeah. I do, and
Bensinger, Menkes, and Cotant.
having practiced
Gentlemen.
a bit of workers' compensation back in my day when I practiced,
Yeah.
I can tell you that I get that there are whores in the industry. Okay, I get that completely, and I get that that's a shortcoming in the system, and I wish it were easily addressed.
And that's a legislative issue.
That is a legislative issue. That's exactly right. So I understand that, and I understand your perspective on that, but you're not going to change that relative to your circumstance. So, now I lost my train of thought, but relative to other complaints that you want to lodge, that's the limitation on your right to free speech, because it's about, from their perspective, protecting the integrity of the plan, because they've got hundreds of other cases that are similar than yours, worse than yours,